Today we are covering buyer-broker agreements, a topic heavily tested on the California real estate exam. As of January 1, 2025, California law requires a written buyer-broker agreement to be signed before a buyer's agent can receive a commission. The exam will test your understanding of the difference between exclusive and non-exclusive agreements. An exclusive buyer-broker agreement designates the agent as the buyer's sole representative, meaning the buyer cannot work with another agent. In contrast, a non-exclusive agreement allows the buyer to work with multiple agents, and only the agent who is the procuring cause of the purchase earns the commission. The California Association of Realtors, or CAR, provides standard forms for these agreements, like the BR11, which is a non-exclusive and revocable agreement. The exam frequently features questions about broker compensation. Remember that commissions are always negotiable, and there is no standard rate. The agreement must clearly state the compensation, which can be a percentage, a fixed fee, or an hourly rate. A common exam trap involves scenarios where the seller offers a commission that is less than what's specified in the buyer-broker agreement. In this case, the buyer is responsible for paying the difference, unless negotiated otherwise. Agency duties are another critical area. A buyer's agent owes the buyer fiduciary duties of utmost care, integrity, honesty, and loyalty. This is often remembered by the acronym OLDCAR: obedience, loyalty, disclosure, confidentiality, accounting, and reasonable care. For example, if a buyer's agent knows the seller is on the verge of foreclosure and would accept a lower price, the duty of loyalty requires the agent to disclose this to their buyer client. Conversely, a dual agent representing both buyer and seller cannot disclose confidential information, like the buyer's willingness to pay more, without express permission. The duration of the agreement is negotiable, but often set for a period like 90 days. Termination rights are a key distinction tested on the exam. A non-exclusive agreement can typically be canceled immediately with written notice. However, an exclusive agreement often requires a 30-day written notice for unilateral cancellation. Be aware of the continuation period or safety clause. If a buyer purchases a property shown to them by their former agent within a specified period after termination, that agent may still be entitled to a commission. Finally, agency disclosure is paramount. California's Civil Code requires agents to provide the disclosure regarding real estate agency relationship form at the first substantive contact with a buyer. This ensures the buyer understands who the agent represents before any significant discussions occur. A common exam question will test the timing of this disclosure. For a memorable phrase, remember: disclose, elect, confirm. First, you disclose the agency options. Then the client elects the type of representation. And finally, you confirm that choice in writing within the agreement. For free practice questions, AI-powered explanations, and more exam prep tools, visit openexamprep.com. That's openexamprep, all one word, .com.